each of those elements in Section 7 of the Civil Procedure Act, which we have enumerated herein. It signally failed to do so. In fact, it made no effort to. We find no substance with respect in Mr. Kilonzo's submission before us that insofar as the petition that was before the High Court made several references to previous elections, it was concerned with the presidential election of 2013, and therefore all issues raised in the said petition were res judicata, as they ought to have been raised in Raila Odinga and 2 others versus IBC and 3 others. We do not think that mere reference to the past election, to that past election, brings the matter within the purview of res judicata. The requirement is that the issue raised in the later litigation should have been directly and substantially in issue in the former. They were not. It is a stretching of the facts a wee bit too far to describe the petition that was before the High Court as an attempt to relitigate the Supreme Court verdict on the 2013 presidential poll. We are quite clear in our mind that the central issue in the Raila Odinga and 2 others versus IBC and 3 others, namely the validity of the 2013 presidential poll, is not before us in this appeal. We are equally certain that the direct and substantial issue before us, namely the constitutionality of Section 39, 2 and 3 of the Elections Act, was not raised before and determined by the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. On that score alone, the plea of res judicata was for rejection. The non-commonality of issues apart, the plea of res judicata was bound to fail on the basis that the parties between the 2 sets of proceedings are not the same, or those claiming under the same parties and litigating under the same title. This is the only other aspect of the res judicata requirement that Mr. Kilonzo addressed, and we recorded him as contending that the commonality of parties is supplied by, quote, the fact that Maina Kiai, the first respondent, is a director of AFRICOG, which participated in the 2013 presidential election petition before the Supreme Court, end of quote. He went on to assert that the first respondent ought to have raised all the issues now before us in those proceedings at the Supreme Court instead of litigating by installments. With respect to Mr. Kilonzo, the reference to the first respondent herein as a party in Raila Odinga and 2 others versus IBC and 3 others is untenable. First, the first respondent is separate and distinct from AFRICOG, even were we to accept that he is the director thereof. Further and more fundamentally, AFRICOG was not a party to any of the petitions consolidated and decided by the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. One, Gladwell Gadoni Otieno, who is associated with AFRICOG, was a party in petition number 4, but mere association as a basis for mounting a res judicata challenge to a suit would be an absurd extrapolation. Given those plain facts, the res judicata objection stood absolutely no chance of succeeding, and its rejection by the High Court was inevitable. The challenge to the learned judge's sound and solid finding and holding on the same is doomed to suffer the same fate, and we dismiss it. Before we consider whether the High Court erred by declaring the impugned provisions of the Act and the regulations unconstitutional, we should address the issue of interpretation of the Constitution generally, because that declaration was premised on the interpretation of Articles 86 and 138. Interpretation of a constitution entails an inquiry into the intention of the drafters to discern the meaning of its provisions. In enunciating the fundamentals, a delicate balancing act requires to be undertaken of the textual, the contextual, the intent and purport, as well as the spirit of the Constitution. To begin with, the text is construed to establish the meaning of the words and the language, care being taken to ensure that a literal or rigid interpretation is eschewed. This should be placed in context, that is, the objectives of the enactment. The Supreme Court of India aptly considered text and context in interpretation in the case of Reserve Bank of India versus Peerless General Finance and Investment Company and others, when it stated that, quote, interpretation must depend on the text and the context. They are the basis of interpretation. One may well say, if the text is the texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual. End of quote. In contemplating the provisions, the intent and purport of the Constitution, the objectives and aspirations, as well as the mischief to be remedied, are also brought into focus. Yet another imperative is the principle of harmonious interpretation. This was considered in the United States Supreme Court case of South Dakota versus North Carolina, when it was observed that, quote, it is an elementary rule of constitutional construction that no one provision of the Constitution is to be segregated from all the others to be considered alone, but all provisions bearing on a particular subject are to be brought into view and to be interpreted as to effectuate the general purpose of the instrument. The above outlined principles were appropriately summarized by the Constitutional Court of Uganda in Kigula and others versus the Attorney General in the following terms, which we quote. The principles applicable in the interpretation of the Constitution include the widest construction possible in its context should be given according to the ordinary meaning of the whole of the words used. The entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other. All provisions bearing on a particular issue should be considered together to give effect to the purpose of the instrument. The Constitution should be given a generous and purposive interpretation to realize the full benefit of the guaranteed rights. The Constitution of Uganda, and would apply to Kenya, enjoins courts in the country to exercise judicial power in conformity with law and with the values, norms, and aspirations of the people. End of quote. See also the case of Olum and another. From this summation, it is evident that what is required is a purposive interpretation that brings into focus the principles, purposes, and peculiarities of the enactment, as well as the historical context and extrinsic materials that form an integral part of the Constitution's existence. A purposive approach was adopted in the interpretation of the Hong Kong Basic Law in the case of Tallying and another versus the Director of Immigration. The Hong Kong Supreme Court outlined the approach thus, and we quote, "It is generally accepted that in the interpretation of a constitution such as the Basic Law, a basic purposive approach is to be applied. The adoption of a purposive approach is necessary because the Constitution states general principles and expresses purposes without condescending to particularity and definition of terms. Gaps and ambiguities are bound to arise, and in resolving them, the courts are bound to give effect to the principles and purposes declared in and to be ascertained from the purposes declared in and to be ascertained from the Constitution and relevant extrinsic materials. So, in ascertaining the true meaning of the instrument, the court must consider the purpose of the instrument and its relevant provisions as well as the language of its text in the light of the context being of particular importance in the interpretation of a constitutional instrument. End of quote. Constructively speaking, a correlation can be established between the principles of interpretation under discussion and the prescriptive manner in which the Constitution in Article 259 directs that the Constitution be interpreted. It stipulates and requires this Constitution shall be interpreted in the manner that A. promotes its purposes, values, and principles. B. advances the rule of law and human rights and fundamental freedoms in the Bill of Rights. C. permits the development of the law. And D. contributes to good governance. And 3. every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. End of quote. In adherence to these principles, the Supreme Court, in the case of Gatirao Peter Munya versus Dixon Mwenda Giringi, prescribed a purposive approach whenever the Constitution is to be interpreted. And we quote, in Pepper versus Hart, Lord Griffiths observed that the purposive approach to legislative interpretation has evolved to resolve ambiguities in meaning. In this regard, where the literal words used in a statute create an ambiguity, the court is not to be held captive to such phraseology. Where the court is not sure of what the legislature meant, it is free to look beyond the words themselves and consider the historical context underpinning the legislation. The learned judge thus pronounced himself, and they quote him, "The object of the court in interpreting legislation is to give effect, so far as the language permits, to the intention of the legislature. If the language proves to be ambiguous, I can see no sound reason not to consult Hansard to see if there is a clear statement of the meaning that the words were intended to carry. The days have long passed when courts adopted a strict constructionist view of interpretation, which required them to adopt the literal meaning of the language. The courts now adopt a purposive approach which seeks to give effect to the true purpose of legislation and are prepared to look at such extraneous material that bears upon the background against which the legislation was enacted." End of quote. And end of quote. In conjunction with the purposive approach, the Supreme Court has also advocated for the application of a holistic interpretation as seen in the matter of the Kenya National Human Rights Commission, Supreme Court Advisory Opinion number 1 of 2012, where it stated as follows, and we quote, "But what is meant by a holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions so as to maintain a rational explication of what the Constitution must be taken to mean in light of its history, of the issues in dispute, and of the prevailing circumstances. Such scheme of interpretation does not mean an unbridled extrapolation of discrete constitutional provisions in each other so as to arrive at a desired result." End of quote. But that is not all. In pursuance of constitutional interpretation, yet another dynamic is constantly at play and requires consideration, and that is the spirit of the Constitution. The Supreme Court, in the matter of the Interim Independent Electoral Commission, cited Justice Mohammed in the Namibian case of State versus Acheson, where, in reference to the spirit of the Constitution, the judge observed that, and they quoted him, "The Constitution of a nation is not simply a statute which mechanically defines the structures of government and the relationship of government and the governed. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must, therefore, preside and permeate the process of judicial interpretation and judicial discretion." See also William Hard's title, "The Spirit of the Constitution." We dare say that in the context of the Constitution, there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Also envisaged as a component of the spirit are the distinct political undertones that are interwoven into the fabric of various provisions. This was appreciated by the majority of the Supreme Court in the case of the matter of the principle of gender representation in the National Assembly and the Senate, where the court at paragraph 54 asserted, and we quote that quote, "Certain provisions of the Constitution of Kenya have to be perceived in the context of such variable ground situations and of such open texture in their scope for necessary public actions." A consideration of different constitutions shows that they are often in different styles and modes of expression. Some constitutions are highly legalistic and minimalistic as regards express safeguards and public commitment. But the Kenya Constitution fuses this approach with declarations of general principles and statements of policy. Such principles of policy declarations signify a value system, an ethos, a culture, and a political environment within which the citizens aspire to conduct their affairs and to interact among themselves and with their public institutions. Where a constitution takes such a fused form in its terms, we believe a court of law ought to keep an open mind while interpreting its provisions. In such circumstances, we are inclined to in favor of an interpretation that contributes to the development of both the prescribed norm and the declared principle or policy, and care should be taken not to substitute one for the other. In our opinion, the norm of the kind in question here should be interpreted in such a manner as to contribute to the enhancement and delineation of the relevant principle, while a principle should be so interpreted as to contribute to the clarification of the content and elements of the norm. End of quote. Finally, in Center for Rights, Education and Awareness and another versus John Harun Mwau and 6 others, the Honorable Mr. Justice Gidinji of this Court of Appeal, with whom we respectfully agree, outlined other important principles of interpretation of the Constitution and stated as follows, and we happily quote him. "There are other important principles which apply to the construction of statutes, which in my view also apply to the construction of a constitution, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result. The presumption against unworkable or improbable result, meaning that a court should find against a construction which produces an unworkable or impracticable result. Presumption against anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result, and the presumption against artificial result, meaning that a court should find against a construction that produces artificial result, and lastly, the principle that the law should serve the public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to the public interest, economic, social, and political, or otherwise. End of quote. Ultimately, we are clear in our minds that, owing to the prescriptive requirements of Article 259 and the various pronouncements of the courts that we have adverted to, we are compelled to adopt a purposive approach when interpreting the Constitution, having regard to the intent and purpose, the historical, socio-political context, the values, aspirations, and the spirit of the Constitution. We do not agree with the appellant or with the Honorable Attorney General that in this appeal, interpretation should be formalistic or restricted to the law, to the legal text alone, and the literal meaning of the provisions. And neither do we subscribe to the proposition that a purposive or normative interpretation is strictly limited to the Bill of Rights only. The criticism directed at the High Court in this regard is not justified. The last ground, which is the gravamen of this appeal, is the constitutionality of the impugned provisions of the Act and the regulations made thereunder. We reiterate that the court below was invited to consider whether Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c are inconsistent with Article 86 and 130, Articles 86 and 138 sub Article 3 of the Constitution, and to issue the appropriate declarations. In granting the petition, the High Court found in part that there was tension between Regulation 83 sub-regulation 2 and sub-regulation 3. That under the latter, the decision of the constituency returning officer on the validity or otherwise of a ballot paper or a vote is final except in an election petition, while the former regulation, on the other hand, makes the results for a presidential election declared by the returning officer subject to confirmation by the appellant. Borrowing the meaning of the word confirm from Black's Law Dictionary, 9th edition, the learned judges understood the phrase subject to confirmation as used in Regulation 83 sub-regulation 2 to mean that once the constituency returning officer has tallied, verified, and declared the results of a presidential election, those results would be subject to a further verification, approval, disapproval, or declaration by the appellant or its chairperson at the National Tallying Center. To that extent, they found the two sub-regulations to be in direct conflict. The learned judges found further controversy in Regulation 87(2)(c), in which it is declared that the results electronically transmitted to the appellant are only provisional. They asked the question, quote, how can the election results which have been tallied, verified and declared to be final under Regulation 83.3 be said to be provisional, temporary or conditional under Regulation 87.2c. They posed again, why and for what reason would a returning officer be transmitting provisional results to the Commission when he has already declared the winner and issued a certificate? End of quote. In addition, they noted that since the constituency returning officer is required to retain in safe custody for a period of 3 years after the results of the elections all documents relating to the election, there can be no basis for the appellant to purport to engage in any exercise of confirming the results. Finding a parallel in the Supreme Court decision of George Mike Wanjohi versus Stephen Kariuki and 2 others, the learned judges concluded on this point that once the constituency returning officer has declared the results, those results are final and only a court of competent jurisdiction can interfere with them. In the cited case, it was noted that, and we quote, this is the Supreme Court, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of the state. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. End of quote. They also made reference to Hassan Ali Joho and another versus Suleiman Said Shabal and 2 others, and reached a determination that to the extent that Section 39(2) and 3 treats results announced by the constituency returning officer as provisional, the 2 subsections are inconsistent and contrary to Article 86 and 138 sub-article 2 of the Constitution, and therefore void, that the appellant has no power to verify or confirm the results announced by the constituency returning officer. In the end, the learned judges granted the petition by declaring that, quote, to the extent that Section 39(2) and 3 of the Elections Act provides that the results declared by the returning officer are provisional, that is contrary to Article 86 and 138 sub-article 2 of the Constitution. To the extent that Regulation 83(2) of the Elections General Regulations 2012 provides that the results of the returning officer are subject to the confirmation by the Commission, that is contrary to Article 86 and 138(2) of the Constitution. To the extent that Regulation 87(2)c of the Election General Regulations 2012 provides that the results that the returning officer shall transmit electronically to the Commission are provisional, that is contrary to Article 86 and 138 sub-article 2 of the Constitution. End of quote. The highlighted phrase subject to confirmation and the word provisional were the main cause of discomfort, prompting the first, second and third respondents to petition the High Court for relief. It is the construction of those very words by the 3 learned judges that has now aggrieved the appellant to come to this court. As we now turn to the heart of this appeal, it is apposite for the clear appreciation of the long, windy, and sometimes turbulent journey this nation has traveled to get to where we are today, that we retrace our electoral history. Because elections determine political winners and losers, electoral processes from voter registration through to declaration of results have long been targeted for manipulation and are the foremost cause of electoral conflicts. Such manipulation, or sometimes even the mere threat of it, weakens public confidence in democratic processes, in the courts, in security agencies, in the legislature, and in the end can erode the legitimacy of governance institutions. Lack of trust among political parties and players and suspicions of electoral fraud have in the past catalyzed polarization and triggered bloody ethnic conflicts in nearly every election cycle. The reforms to electoral processes that have been initiated in Kenya have been triggered by, among other factors, failure to deliver credible and acceptable elections. Pressure from the public has been instrumental in the introduction of some of the electoral reforms that have been witnessed, as was the case in 1997 when, under the auspices of the Inter-Parties Parliamentary Group, IPPG, far-reaching constitutional changes were introduced. Global obligations for transparent and accurate electoral administration have played an equally important role in setting the yardsticks by which the electoral processes and administration are to be assessed in future. But even with these many strides, the fear of manipulation of the election results and interference with the integrity of the electoral process generally persists. Nothing demonstrates this fear, mistrust, and weak processes better than the following passages from the Kriegler report. How over the years the country has done the same thing over and over again with the same obvious result, which is failure. Because of its bearing on our determination of this appeal and historical underpinning, we quote those passages in extenso. Quote, concerns about the counting, tallying, transmission, and announcement of results are not new in Kenya. In 1992, on the occasion of the first multi-party elections, an International Republican Institute pre-election report noted that, and they quoted, the electoral law does not stipulate the mechanism for transmittal of constituency results to the ECK then in Nairobi, and urges that this information be transmitted in a timely way. End of that quote within a quote. This quote continues. The report of the Commonwealth Observer Group was more drastic in its evaluation, and this is what it said. Given the poor communication between ECK and the returning officers and between returning officers and presiding officers, the lack of coordination and inconsistencies in dealing with clear-cut problems, we can only conclude that neither the polling day arrangements nor the counting processes were adequately designed or carried out to meet the specific situations and needs which the Kenyan electoral environment required. End of that quote within a quote. The situation had not much improved by the 1997 general elections. A joint report of the Institute for Education in Democracy, IED, the Catholic Justice and Peace Commission, and the National Council of Churches of Kenya recommended that, quote within a quote, "It is vital to have a speedy counting exercise with results verified by all parties and announced immediately after the count is completed. This is the only way in which public confidence in the results can be ensured." Unfortunately, this was not the case in 1997. End of that quote. According to the report, the situation was no different in the year 2002. It was noted that initial results to the public were first released through the media, as ECK was not fast enough to release the results due to what was attributed to poor network in some of the polling stations. End of quote. The violence that convulsed Kenya after the disputed 2007 presidential election is a scar etched in our history and engraved in our hearts and souls forever. Regarding its causation, the Kriegler report came to the irrefutable conclusion that, and we quote, "The ECK was not able to manage the counting, tallying, and results announcement processes in such a way that it secured the integrity of the electoral process at either the presidential or the parliamentary level. If one, be it a voter, a candidate, a media representative, a party leader, an election observer, cannot trust the accuracy of the election results published by an EMB, that's an electoral management body, then nothing is left, and the political system loses credibility as well as legitimacy." End of quote. Because of their relevance, we once more here below reproduce 3 of the 4 recommendations made in the Kriegler report regarding the need for integrity in the counting, tallying, and the ultimate announcement of results. Quote, "IREC recommends that the ECK integrate the various descriptions of the entire counting and tallying procedure into one document and one document only, which will then be the principal description and must be adhered to. The need for such descriptive regulations does not depend on possible changes in the counting and tallying system." Next, IREC recommends that without delay, ECK start having developed an integrated and secure tallying and data transmission system, which will allow computerized data entry and tallying at constituencies, secure simultaneous transmissions of individual polling station level data to the National Tallying Center, and the integration of this results handling system in a progressive election results announcement system. And IREC recommends that ample time be allowed for verifying provisional results so that they are declared final or official only once there is no risk that errors may still be found or non-frivolous objections raised. Most countries allow 1 or 2 weeks for this. There must be sufficient time to check the provisional results, which are given status as final results only when all objections have been considered, all checks and rechecks conducted, and the final verdict issued by the proper authorities. Given a clear explanation of what a provisional result is, there is no problem in making voters understand that election results are so important that they can be declared final only once they have been properly scrutinized and checked. End of quote. Finally, on the history of elections in Kenya, and talking specifically about the last elections of 2013. The recent report of the Joint Parliamentary Select Committee on the matters relating to the IEBC, also called the Kiraito Orengo Report, observed at paragraph 452, and we quote, "There were challenges experienced with the electronic transmission of the results, including that only 17,000 of the 33,000 polling stations managed to transmit results before it was overwhelmed by some technical hitches. This alternative method of getting results had to be discontinued when it became too slow, and although the problem was identified and fixed, a number of officials had abandoned the transmission as they took hard copies of the same to tallying centers. There were also network failures and suspicions of system hacking, which necessitated a reversion to physical submission of the results." End of quote. In paragraphs 454 to 460, the report sets forth and considers the provisions of Articles 86 and 138, Section 39 of the Act, and the regulations which are the subject of this appeal. It notes that several stakeholders were concerned about the venue, manner, and process of declaration of final and conclusive elections results. There was near unanimity in opinion that since the first level of declaration of results is at the polling station, those results should be final and should only be challenged in a court of law. That the form filled out for the declaration of results at the polling station should be the primary election form, and all other forms can only be tallies of the final results rather than confirmation forms. That, for those reasons, the stakeholders recommended to the committee that Regulations 76, 77, and 78 be amended to provide for conclusive determination of ballots at polling stations and amend the relevant electoral forms to align them with this recommendation, and that further the Elections Act be amended to provide that the results announced at the polling station be final and definite. These recommendations were informed, according to the report, by concerns based on past experience where some returning officers would annul results that had been announced at polling stations, causing uncertainty and tension in the electorate. In the committee's view, it was the mischief that informed the enactment of Article 138 Subarticle 3C of the Constitution, which requires that, quote, in a presidential election, C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result, end of quote. In the end, taking into account the very many views presented, the committee recommended that the Elections Act be amended to provide for the electronic transmission of the tabulated results of election for the president from a polling station to the constituency tallying centers and ultimately to the national tallying center.
That invaluable background enables us to now consider the conjoined twin question whether Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2) are inconsistent with Articles 86 and 38(2). And the point at which to start that consideration is Article 2(1) and 4, where the Constitution declares itself the supreme law that binds all persons and all state organs, and therefore, quote, any law, including customary law, that is inconsistent with this Constitution is void to the extent of the inconsistency, and any act or omission in contravention of this Constitution is invalid. End quote. The power of the court to review acts of the legislative and executive arms of government which can be demonstrated as affecting constitutional rights and fundamental freedoms of the citizen is from this authoritative provision axiomatic. Yet the exercise of this power by the courts, though constitutionally sanctioned, has been a source of endless misunderstanding and friction. Whenever it is exercised, the executive and the legislative arms of government have many a time accused the judicial arm of overreaching itself. This notwithstanding, the judiciary must always be true to the Constitution, whose edicts it must declare without fear or favor, and accept that it may not always receive accolades for doing so. Generally speaking, the legislation is presumed to be constitutional because it is assumed that in enacting the law, the legislature does so on behalf of the populace with a view to addressing their needs and problems. The people's representatives are expected to enact only laws that they consider to be reasonable for the purpose for which they are enacted. But this is a rebuttable presumption. As such, the power to question the constitutionality of a statute is circumscribed by many conditions. For example, it was stated in the Canadian case of Queen versus Big M Drug Mart, which has been applied in many decisions in this country, that, and we quote, both purpose and effect are relevant in determining constitutionality. Either an constitutional purpose or an unconstitutional effect can invalidate legislation. All legislation is animated by an object the legislature intends to achieve. The object is realized through impact produced by the operation and application of the legislation. Purpose and effect, respectively, in the sense of the legislation's object and its ultimate impact, are clearly linked, if not indivisible. Intended and achieved effects have been looked to for guidance in ascertaining the legislation's object and thus validity. End quote. Similarly, in the often cited judgment of the Constitutional Court of Uganda, which we referred to earlier, Olum and another, the court restated those principles thus: to determine the constitutionality of a section of a statute or act of parliament, the court has to consider the purpose and effect of the impugned statute or section thereof. If its purpose does not infringe a right guaranteed by the Constitution, the court has to go further and examine the effect of the implementation. If either its purpose or the effect of its implementation infringes a right guaranteed by the Constitution, the impugned statute or section thereof shall be declared unconstitutional, end quotes. The question before the High Court, and indeed in this appeal, is whether the purpose for which Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c) were promulgated, or the effect of their implementation infringes any provision of the Constitution. The burden was on the first, second, and third respondents to demonstrate that the impugned provisions were enacted or made for an unconstitutional purpose, or that in their operation and application they have an unconstitutional effect. We start by testing those provisions against Articles 86C and 138(3)(c), the general constitutional principles and the general principles of the electoral system in Article 81. On the general principle of the electoral system, Article 81 provides, quote, "The electoral system shall comply with the following principles: A. Freedom of citizens to exercise their political rights under Article 38. B. Free and fair elections which are 2. Free from violence, intimidation, improper influence, or corruption. 3. Conducted by an independent body. 4. Transparent. And 5. Administered in an impartial, neutral, efficient, accurate, and accountable manner." End quote. Article 82 enjoins Parliament to enact legislation on election that will ensure that, quote, "voting at every election is A. simple and B. transparent." End quote. Regarding voting method, Article 86 commands that, we quote, at every election, the Independent Electoral and Boundaries Commission shall ensure, A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling station are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including the safekeeping of election materials. End quotes. Article 138(3)(c), on the other hand, stipulates, we quote again, "In a presidential election, C, after counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result." End quote. How are Section 39(2) of the Act and Regulations 83(2) and 87(2)(c said to be inconsistent with the foregoing provisions and principles? Section 39, 2 and 3 states as follows, we quote, "The Commission shall determine, declare and publish the results of an election immediately after close of polling. Before determining and declaring the final result of an election under subsection 1, the Commission may announce the provisional results of an election." We have emphasized the Commission may announce the provisional results of an election. 3. The Commission shall announce the provisional, again emphasize the provisional and final results in the order in which the tallying of the result is completed, end quotes. We also reproduce here below Regulation 83.2 and 87.2c. 83.2 says, "The results of the presidential election in a constituency shown in Form 34 shall be," and we again emphasize, "shall be subject to confirmation by the Commission after a tally of all the votes cast in the election." 87.2, "The returning officer shall, after tallying of votes at the constituency level, A, announce the result cast for all candidates, B, issue certificates to persons elected in the National Assembly and County Assembly elections in Form 38 set out in the schedule, and C, electronically transmit," again emphasis, electronically transmit the provisional result to the Commission, end quotes. The first, second, and third respondents are concerned that whereas Article 86 and Article 138 make no reference or mention of the results from the constituency being provisional or subject to any confirmation, the terms of the impugned provisions suggest that those results can be interfered with at the National Tallying Center by the chairperson of the appellant, who it designates the returning officer for the presidential election, yet the results announced at the constituency tallying center are final. Giving his views before the Kiraitu Orengo Committee, the then chairperson of the appellant, Ahmed Isaac Hassan, explained the mischief and reason why those results were considered provisional and subject to confirmation. He is recorded in the report as having said the following, quote, "The chairperson further submitted that the results received under the system were provisional results under the Elections Act and the Elections General Regulations, because every returning officer had to bring the physical form to the county returning officer." Now they quote the chairperson himself. This is what he said. "So they do not replace the official legal announcement of the results by the returning officer and the paperwork on the forms 36, 37, and 38. These forms in the Elections Act are prescribed forms and they form part of the law." End quotes. We are still quoting the Kiraitu Orengo report. They say at paragraph 486, "With regard to the current transmission and declaration of results, the chairperson of the Independent Electoral and Boundaries Commission stated that," and this again quoting the former chairman, "a presiding officer is the first point of call for results. He opens the ballot box, counts the ballot papers first for president, and declares the results there." End of quote. the then chairperson, further gave a roadmap of how the results of the 2013 elections were transmitted from the constituency to the council.